Dr. Simranjeet Kaur Gill, Professor of Law, City University, Ludhiana. Today, we will discuss the topic Meaning of Legal Theory. Jurisprudence is the philosophy of law, while legal theory is the systematic study of law. In other words, jurisprudence is the abstract reasoning about the law, while legal theory is the concrete analysis of law. Jurists typically focus on jurisprudence, while lawyers and philosophers of law focus on legal theory. However, there are many overlaps between these two disciplines. Jurisprudence, in its simplest form, is the philosophy of law. It includes the study and analysis of law generally, as well as its systems, institutions, and the principles. Legal theory, meanwhile, focuses specifically on the law in practice, how it functions and operates within the societies. So, while jurisprudence and legal theory are intrinsically linked and often used synonymously, one legal theory is actually a subset of the other. Jurisprudence, in a prior installment of the legal theory lexicon, we explored the difference between positive and normative legal theories. Positive legal theory attempts to explain and predict legal behavior, especially the content of legal rules. Normative legal theory makes claims about what those rules should be. This week's post is about an important and a familiar concept in positive legal theory, the idea of a functional explanation. The meaning of legal theory extends beyond the mere understanding of laws. It encompasses a broader scope that includes legal, moral, philosophical, and societal influences on the English legal system. The purpose of the legal theory is to equip students with the critical awareness, enabling them to navigate the complexity and challenges inherent in the legal environment. What's its relationship between legal theory and the jurisprudence? The words jurisprudence and the legal theory are often used interchangeably, but they have different meanings. Jurisprudence is the philosophy of law, while legal theory is the examination and analysis of how the law works. In other words, jurisprudence asks why law exists and how they should be interpreted, while legal theory looks at what law is currently doing and tries to figure out why it's effective or not. Though they are related, these two concepts are important to understand separately. Jurisprudence is the philosophy of law, while legal theory is the academic study of the law. Jurisprudence asks questions about the nature of law, such as what it is and why it exists. On the other hand, the legal theory focuses on analyzing specific legal doctrine and concept. One important distinction between jurisprudence and legal theory is that jurisprudence does not necessarily require formal law training or legal scholarship. In contrast, legal theory typically requires a background in either the philosophy or the law. This means that jurists may approach the question of law from a more general perspective. At the same time, legal theorists are likely to have a more specialized understanding of a particular areas of law. Now, we will discuss the types of legal theory. One barrier to the greater dialogue and understanding within the jurisprudence is the inability to appreciate the variety of forms and purposes among the different theories or about the nature of the law. Legal theorists are frequently to blame for the confusion about the methodological issues, as they are often not as clear as they might be. Regarding the nature of claims they are making, descriptive versus prescriptive, conceptual versus empirical, or regarding the larger project of which their theories are a part. This entry attempts to offer a rough overview of the types and the purposes of legal theory. The focus is primarily on the theories about the nature of law. Other types of theory, for example, theories of doctrinal areas of law, analysis of legal concepts, or the best approach to legal or judicial reasoning, may warrant a different analysis. Normative legal theory. The view that the real purpose of normative legal theory is to explore the integrity of legal ideas and legal reasoning, thus assisting lawyers to rationalize legal doctrine by providing a coherent structure and a systematic unity of the doctrine is, in a considered opinion, valid and intellectually sound. Inherent in the evaluation of normative theories' search for the structure and unity in law, as examined in this essay, is the determination to see things as they are, to resist metaphysical allurements, and to probe analytically and with the vigor into the fundamental concept of law, on which so much confused thinking existed. It presents law as a phenomenon susceptible to scientific analysis and investigation. Austin, for example, attempted to establish the autonomy of jurisprudence as a separate field of study and placed it on a factual and scientific basis. The effort made by the normative legal theory to establish a law from the politics is readily apparent. What needs to be examined is just how successful this effort has been. If we talk about importance of normative legal theory, in common parlance, normative means describing or setting standards or rules which should be followed. Normative legal theory attempts to explain the nature of law almost exclusively through philosophical analysis and clarification of the values, concepts, principles, rules, modes of reasoning entailed and are presupposed by the legal doctrine. Normative legal theory concerns itself to offering a general account of the nature of law and tends to entail the creation of some sharp internal-external dichotomy marking the legal from the non-legal. Normative legal theory is often said to be concerned to answer the question, what is law philosophically in the terms of logical structures and rational foundations of doctrine. Normative legal theory has its weaknesses, but its strength has been in its commitment to make legal knowledge a system of reason. A reference to the works of Bentham, Austin, Kelson and H.L.A. Hart in our view will help us understand normative legal theory in context and perspective of social reality in which they lived. Legal theory is taken to refer to the systematic theoretical analysis of the nature of law, laws or legal institution in general. It seeks specifically to develop theoretical understanding of the nature of a law as a social phenomenon, while philosophical justification of the particular aims or tasks of the law are not irrelevant to this concern and may follow directly from the certain types of legal theory such as natural law. They are not central to it. It follows from this definition of legal theory that both legal philosophy and sociology of law can and do contribute to it. Cotterell terms legal philosophy's contribution to the legal theory, normative legal theory, and the sociology of law's contribution to it, empirical legal theory. He admits that the distinction or demarcation between the two concepts is more a matter of emphasis than of rigid demarcation. Just as in legal philosophy's conceptual inquiries as opposed to those of sociology of law. Jeremy Bentham, John Austin, Hans Kelsen, and H.L.A. Hart have contributed greatly to the literature of legal philosophy. They have contributed to the legal theory in such a significant way that their influence is still being felt today. Their work has shaped the jurisprudence of many parts of the world and continues to be of interest of scholars, judges, governments, and lawyers. What is legal philosophy or a normative legal theory's contribution to the wider world of political and legal activities? Lawyers seek rationality, system, and order in the legal doctrine. They seek to explore the integrity of the legal ideas and the legal reasoning, so as to be able to rationalize legal doctrine. Indeed, their ability to interpret the doctrine and predict the outcome of litigation or the effects of the legal documents depends on this. Lawyers seek conceptual clarity in legal doctrine. Normative legal theory serves this function quite effectively, in our view. Legal philosophy's contribution to the modern legal theory has been predominantly by lawyers, addressed primarily to the lawyers. Justification of the normative legal theory often emphasizes its practical role in the improvement of law. Normative legal theory and positivism. An overview. Bentham, Austin, Kelsen, and Hart can be stated earlier be described as belonging to the positivist movement, which began around the 19th century. Prevailing the theories of natural law share the features of running away from the realities of actual law in order to discover in the nature of reasons principle of universal validity. Unverified hypotheses of this sort fail to satisfy the intelligence of an age nurtured in the critical spirit of scientific learning. Scrutiny of natural law postulates had damaging result, as they were found to be without foundation or else the product of extrapolation. The term positivism has many meanings, which were tabulated by Professor Hart as follows. Laws are commands. This meaning is associated with two founders of British positivism, Bentham and his disciple Austin. The analysis of the legal concept is worth pursuing, distinct from sociological and historical inquiries. distinct from the critical evaluation. Decisions can be deducted logically from predetermined rules without recourse to social aims, policy or morality. Moral judgments cannot be established or defended by rational arguments, evidence or proof. The law as it is actually laid down positum has to be kept separate from the law as it ought to be. Descriptive legal theory, a tradition of a thought in a legal theory woven through the work of Jeremy Bentham and John Austin in the 19th century, and that of a Hans Kelsen and H.L.A. Hart in the 20th, contends that it is possible to construct successful theories of law which are, in a certain sense, discussed more fully below descriptive in character. According to this approach, it is an important task of the legal theory to identify and explain what law is, and this project can be undertaken relatively independently of and prior to attempting to moral, evaluate or justify law. Bentham, Austin, Kelsen and Hart also share the methodological goal of attempting to explain the nature of law. That is to say, the theories attempt to identify and adequately explain law's essential properties, those features of law which make it into what it is. These theorists then are seeking a descriptive account of the nature of law and believe that it is possible to answer questions such as, is it in the nature of law that it can be identified purely by reference to the social facts? Is caution an essential feature of law? And do legal system necessarily claims authority over their subjects relatively, independently of and prior to answering the question such as, does that which we identify as law possesses any moral qualities? Can the exercise of the caution via law be justified? And under what condition do the legal system possesses legitimate authority over their subjects? Although this methodological position is a long-standing one, a renewal of interest in the methodological questions in the legal theory in the recent time has been some contemporary jurisprudential scholars' attempt to cast doubt upon the possibility and or usefulness of descriptive accounts of the nature of law. Those harboring such doubts might claim any of all of the following: that it is impossible to delineate those features of law a given theory will focus upon without making evaluative judgments concerning which are the most important or the significant aspect of law to explain, that it is impossible adequately to explain certain features of law without making moral values, judgments regarding law's moral worth or justifiability, that it is necessary to resort to moral or political argumentation concerning the consequences of espousing one view of law as opposed to another. In order to adjudicate between the rival legal theories, the following discussion attempts to throw more light on these doubts and to consider possible responses to them in the service of further illuminating the character and aims of descriptive legal theory. descriptive legal theory, challenges and responses. A simple, although ultimately misleading, account of descriptive legal theory might characterize it as the view that a legal theorist can accurately identify and adequately explain the nature of law without making any value judgment whatsoever. Thus, simply describing law as it is, this is sometimes albeit mistakenly taken to be the view of the descriptive legal theory endorsed by H.L.A. Hart in the postscripts to the second edition of the Concept of Law, where Hart contrasts his own journal and descriptor legal theory with the Ronald Dworkin in the part evaluative and justificatory conception of jurisprudence. Hart in 1994 in different ways the three challenges to this simple account discussed below claim that it is impossible for the legal theory to be value free. In considering these challenges and surveying some contemporary response to them, a revised and more nuanced account of the character and the aims of descriptive legal theory begins to emerge. The role of evaluation of importance and significance in constructing theories of law. One possible challenge to the simple account of descriptive legal theory claims that to construct a successful theory of law, it is necessary to make value judgments regarding the importance and significance of certain features of law and understandings about the law. First, it may be claimed that constructing a theory of anything requires one to make evaluative judgments shifting from the important from the unimportant, the significant from the banal, in order to present a theoretical account rather than a mere mislaying of information. Secondly, it may be further be claimed that in case of theories of law, legal theorists making evaluations concerning the important and significant feature of their subject matter must, from legal theory to interrogative jurisprudence of law, has been traditionally understood as a system of rules and regulations that seeks to maintain social order and resolve disputes. In recent decades, however, legal scholars have begun to explore the idea of an integrative jurisprudence, which calls for the use of law as a tool for the reconciliation and cooperation. This shift away from the traditional legal theory could have far-reaching implications for the practice of law, and it will be interestingly to see how it develops in the years ahead. The next step is to explore how the law can create a more just and equitable society. This involves moving away from legal theory towards interrogative jurisprudence. Interrogative jurisprudence is a way of thinking about the law that emphasizes its role in creating social harmony. It recognizing the law is not an abstract, isolated system, but rather it's a part of the broader social context. Interrogative jurisprudence also acknowledges the need for flexibility and creativity to respond to the changing circumstances. It rejects the idea of single monolithic legal system and instead embraces plurality and diversity. This approach is particularly relevant in today's increasingly complex world, where traditional legal frameworks are no longer adequate. Interrogative jurisprudence provides a way of reconciling the different standards of legal thoughts, and it offers a new perspective on the role of law in society. It is an approach grounded in realism, and it recognizes the limitation of the traditional legal theory. Yet, at the same time, it acknowledges the potential for the law to create a more just and equitable society. In concluding remarks, an important tradition of thought in legal theory contends that it is possible and valuable to identify and explain the nature of law relatively independently of and prior to attempting to morally evaluate or justify law. This methodological approach flows through the work of Bentham, Austin, Kelson, and Hart. However, care must be taken in using the term descriptive in characterizing this position, for these theorists recognize and indeed embrace the idea that certain kind of evaluative judgments are indispensable in constructing successful accounts of the nature of law. This approach is better characterized as recognizing the legal theory cannot and should not be value free, but as denying that legal theories need make judgments concerning the moral values and moral justifiability of law in order to understand its nature. According to this evaluative but not morally evaluative methodological standpoint, questions regarding law's moral value and justifiability and vitally important and are central part of jurisprudential inquiry, but they fall to be considered after we have constructed a normally evaluative account of the nature of law. But they fall to be considered after we have constructed a non-morally evaluative account of the nature of law. Normative legal theory may seek to show how law and politics can remain distinct. However, the works and experiences of the writers discussed here and above shows that the two fields are connected in significant and crucial ways. The search for liberty, justice, rights will compel any serious jurist to look beyond the law into the arena of politics and sociology for the answers. Analytical positivism, as applied by the Austin and the other, attains clarity of concept unattained by the natural law scholars, and this necessarily enhances, in our view, the appreciation of legal phenomena. The scholars discussed in this paper may have succeeded in distilling law from politics, but they have succeeded to a large extent in distilling law from a mass of the other related concepts, thus easing our task of trying to describe and understand legal phenomena. Using normative legal theory as an approach, it is easy in our view to pick out what is law from a myriad of concepts, ideas, norms, rules, and philosophies. Thank you, viewers, for watching this program.